Hi, everybody. Thank you for attending. This is definitely an odd time that we are in right now. To just let you guys know, I've used Zoom before, but this is the first time I'm doing a presentation, so just bear with me on this. My name is attorney Bryana Cross-Bean, and I will be talking about a number of different things today, namely estate planning, elder law, and a bit about probate. A little bit about me is that I've been a practicing attorney since 2013, actually over 7 years now. This is definitely very much turned into my career and my passion. My primary practice areas are estate planning, elder law, and probate. I also do a bit of real estate contracts and small business formation. I am local. I live in Bonnie Lake, but I have 2 offices, one in Puyallup and one in Gig Harbor, and the Gig Harbor office is where I am today. My contact information is below. You can always call my office if you ever need anything. Email is probably the quickest way to get a hold of
communication on the front end.
And everybody, if you can please mute yourselves. And as far as questions go, if this was an in-person presentation, I'd be doing questions throughout, but we'll be taking questions at about 1:45. And I believe, and Athena can correct me if I'm wrong, you submit them through the Whova app, and then she will read them out to me.
Yes, that's correct.
And keep in mind, this presentation today is going to be dense. I'm going to be going through a lot of information relatively quickly. It's okay if you don't fully grasp everything. I do this presentation every single year and have been for about the past 5 years here. And if we weren't in the middle of a pandemic, I'd be doing different presentations at various senior centers. So I'm around. Feel free to come to any of my other presentations when the time does come up. Okay, so we'll start off with estate planning, talk about the essential documents, and then we'll move into probate, and then finally talk about long-term care. Okay, so estate planning is the process of planning for death or incapacity through documents such as wills, durable powers of attorney, and healthcare directives. And those 3 documents that I just mentioned are the essential documents that everybody needs, no matter their situation. If you have 2 pennies to rub together, then you have an estate, and everybody needs to do estate planning no matter their situation. So a will, most of you probably know this, it's the document that allows you to transfer property after you pass away. The durable powers of attorney, now that is the most important estate planning document you can have. That allows you to appoint someone to make medical and financial decisions for you when you're unable to. And the durable power of attorney can either be in one document under a general durable power of attorney, or it can be in 2 documents, durable power of attorney for healthcare and durable power of attorney for finances. There's nothing wrong with either way. On my end, I prefer to do one for healthcare and one for finances, simply because it gives you the ability to appoint one person to make healthcare decisions and another to make financial decisions. Now, if you do choose 2 different agents, you need to be sure that those 2 agents get along. If they don't get along, you are unfortunately looking at potential litigation and family discord. And the reason is that if you need to go into a long-term care facility, one person may say, oh, well, you don't have the money to go into this really nice place. But the person who's managing healthcare might say, oh, no, this place is best suited for mom or dad. So just keep that in mind when you are choosing people to make those decisions for you. And you can have your kids, you can have your spouse, you can have a friend. Some people even choose professionals to perform those functions for a variety of reasons. It's very much up to you and your comfort level. Now, part of the reason I say this is the most important estate planning document you can have is because if you don't have this and you lose mental capacity, maybe you're in an accident or you develop Alzheimer's, then somebody has to make those decisions for you. And if you haven't done the planning with the durable power of attorney, then you're going to need a guardianship. And guardianship is ultimately, it's a court action where your rights are taken away. And a court, as opposed to you, decides who gets to make those decisions for you. So I am very much a big advocate of helping people and empowering people to make their own decisions, because no one knows the best decisions for yourself except for you. So that's another reason just to do estate planning, so that you are the one who's making those decisions. Now, with durable powers of attorney, it's no longer valid when you pass away. So if one of your relatives passes away, who you've been managing their finances, at that point, you can't access their bank account with a durable power of attorney. Now, the final essential document is a healthcare directive. So this is the end of life document that only kicks in essentially when you are brain dead, in a coma, never going to wake up, never going to recover. And this allows you to indicate to doctors whether you want artificial nutrition or hydration. So artificial nutrition, we're talking about a feeding tube. Artificial hydration, we are talking about IV fluids. And this is a very, very important decision, a very personal decision. The healthcare directive is also known as a directive to physicians or a living will. 3 names for the same document. Okay, so beyond those essential estate planning documents, there are other estate planning tools that may or may not be useful for you in your particular situation. The first is called a POLST, P-O-L-S-T, and that stands for Physician Order of Life-Sustaining Treatment. Some of you may have this on your refrigerator. It is a bright green form that you and your doctor both sign. And you need to sign on, you and your doctor need to sign on the front and the back. Some people, some patients and also some doctors forget to do this. So this document specifically applies to paramedics. Now, if you don't have this document, then the default laws kick in, and that is that paramedics and other first responders, like fire department, have the ability to, excuse me, the plane is a tiny bit distracting for me. The paramedics are required to take any and all life-saving measures to resuscitate someone when they are in an emergency situation, unless they see the POLST. Now, this is very much up to you whether you want to get this document done. Now, for someone like me, I'm fairly young, I'm healthy. Now, if I'm found down somewhere and the paramedics are called, for me, by all means, I absolutely want paramedics to pound on my chest and do whatever they can to bring me back to life. However, if I am, let's say, 95 years old and I have end-stage cancer, oops, let's do that. I have end-stage cancer, I am not going to want paramedics pounding on my chest. So somebody in that situation, or any other situation that you choose, having a POLST can be a good option. And that is something that, like I said, is through your doctor's office. Another document that can be useful is something called a community property agreement. So this applies to married couples. And married, there is the default rules that married, any property that's jointly owned, that's acquired during marriage, is jointly owned by the spouses. But any property acquired before and after marriage is presumed to be your own separate property. So what the community property agreement does is it gives you the ability to state that all property is community, which the main purpose of this is to help avoid probate after the first spouse passes. This is something that does need to be recorded with the county recorder's office, but you always want to do that after the first spouse passes away, as opposed to during your lifetime, because it can result in Medicaid ineligibility. And I'll explain that in just a few minutes. Okay. Another document is disposition of remains. So this tells the funeral home what you want done with your body when you pass away. And the default hierarchy of people who get to make those final arrangements for you is your spouse, then your kids, then your parents, then siblings, nieces and nephews, etc. Where this can be particularly useful for somebody is if they are unmarried and let's say they have 2 children, but the children do not get along. And so you really don't want your kids to have to start off fighting and saying, well, mom told me she wanted this. Well, no, mom said she wanted that. And you just want to avoid that as much as you can. Okay, and guardianships we had talked about. It's a last resort. Get a durable power of attorney in place, and in most situations, you'll be in just fine shape. Okay, so I'm going to start moving just a little bit faster, and just to be sure that we have time for questions. So, trusts. There are 2 main categories of trusts. You have testamentary trusts, and you have standalone trusts. Testamentary trust, that is just a fancy term for a kind of trust that goes in a will. So you can have trusts that are, on their own, like a revocable living trust. That's the most common type. Or you can have a testamentary trust, which is kind of a sub-trust that you can include in your will. Now, the most common types of testamentary trusts that I do, one is the special needs trust. I include these in most of my wills because I do elder law as well and a lot of long-term care planning, and I see how useful these are. So this basically is helpful for a child who is on Medicaid or other government benefit, or for a surviving spouse who may be on Medicaid. And so with a lot of those government programs, it restricts how much money you can have. And so with the special needs trust, instead of going directly to that heir, which would result in them losing their benefits, it can go into a special needs trust. And the whoever's managing the trust can go in and take money out to pay for things that the government benefits don't pay for. The next kind of trust that I do a lot of are educational trusts. So that's pretty self-explanatory, allows you to set aside money for normally it's college of children or grandchildren. Then we have a spendthrift trust as the final kind. That is great for heirs who are young and financially irresponsible. Maybe they're in their teens or 20s and haven't quite learned all they need to about how to manage money responsibly. Or if they're an adult child and they have a gambling addiction or something like that, then you can put their inheritance into the trust and say, maybe they get $1,500 per month, as opposed to that whole big lump sum, which they would not spend wisely. Okay, so there are 2 main types of standalone trust. The one that is by far the most common is a revocable living trust. So it's kind of how it sounds. It can be revoked or changed during the person's lifetime. A big purpose of this is to help avoid probate, which may or may not be the best thing for you. Washington does have a fairly simple and straightforward probate process. I really like these for clients who have who are part of blended families. You know, they and their spouse have children from prior marriages. And so if you just have a will, you run the risk of when one spouse passes away, the other one can change their will and disinherit their stepkids. If you have a revocable living trust, you can prevent that. And it can, it's also great if you have property in another state. Now, even though probate is fairly simple and straightforward, if you have probate in, or if you have property in other states, you're going to have to go through probate in those states as well. So going through probate in multiple states can be a bit of a hassle, and a revocable living trust can make this a lot better. Irrevocable trusts. Now, there's probably at least 100 different kinds of irrevocable trusts. Those are, they can't be revoked. So the primary purpose is to prevent or protect assets from taxation and creditors. The two kind of main categories of those are ones for estate tax protection. Now, keep in mind, Washington has an estate tax, but that doesn't kick in until $2.2 million per person. And the federal estate tax, I believe, is about $11.5 million per person. So most people, especially for the federal estate tax, don't need to worry about that. I also do them for assistance with Medicaid eligibility as a way to help guarantee children an inheritance, as long as you do that 5+ years in advance. Now, the Medicaid eligibility trusts can be helpful, but they are complicated, and you really want to talk with an elder law attorney before you even think about doing that, because there's a lot of pitfalls, and they're not useful for everybody. Okay, probate is the legal process of paying off debts and having heirs inherit from you when you pass away. It is a court process, but it's fairly simple and straightforward in Washington. If you're in California, you want to try to avoid it at all costs, but Washington is fairly simple. It is on average a 4 to 6 month process, which is also one of the shortest in the country. Very little court involvement. Typically, it's me, the attorney, appearing once in front of the judge to open up probate, and normally that takes all of 5 or 10 minutes. So it's, like I said, simple and straightforward. However, there are some ways to avoid probate. So one way is to have an estate that is worth less than $100,000. And what I mean by an estate, it's an estate subject to probate. So if you have IRAs, 401ks, life insurance policies, most of those you can indicate that you can put beneficiary designations on those. So those will pass outside of probate and directly to the beneficiaries. And so then that takes it out of your estate for estate tax, for probate purposes. Another way to avoid probate after the first spouse passes away is to have a community property agreement, which converts all separate property into community and gives the surviving spouse the ability to take the deceased spouse's name off of any jointly owned assets. We talked about a revocable living trust. That can be a way to avoid probate. However, with a revocable living trust, that has to be properly funded. That means you want to treat it like a box, and you have to put things in the box, like your house and different financial accounts. If you don't have those accounts and your home properly in the trust, you have just spent a lot of money for a very expensive paperweight, and you still have to go through probate. And then finally, you can, another way to avoid probate is to have assets that are not subject to probate. So let's say that you are renting a home you have a bank account with $10,000 in it, and your son is on your account as a co-owner, and you have an IRA with your son as beneficiary. So you have, in effect, avoided probate because the son jointly owns the account and he's also the beneficiary. Okay, so let's go into long-term care. Long-term care is a very broad kind of definition. It includes anything from home health care, which is where you're, needing someone to come into your home a few times a week to help you bathe and things like that, all the way up to full-blown 24-hour nursing home care. Now, the majority of adults, 70% will need long-term care. That percentage came from a study that was done in 2015. I do expect that percentage to go up as people continue to live longer. So I view that as a probability rather than a possibility that you will need long-term care in the future. So it's good to at least plan for it so that you're not blindsided. Now, the average monthly cost, and I'm talking about in the Pierce County area from what I've seen, is approximately $6,000 per month, which that can get very expensive very quickly. The typical range is anywhere between $1,500 per month, which I rarely ever see. And I've seen at least $15,000 per month. And the $15,000 per month is where you need something like memory care if you have Alzheimer's. Now, most facilities have a 1 to 4 year private pay requirement, and that means that you need to pay out of pocket or via a long-term care policy before they will accept Medicaid. And I'll go into the Medicaid rules in just a few minutes. There are not a lot of great ways to pay for long-term care. One is private pay, so that's paying out of pocket. You can pay via long-term care insurance. You've got Medicaid. There's certain VA benefits, and I'll talk about those as well. And finally, a reverse mortgage can be an option for some people. Reverse mortgages, I will sometimes recommend for clients who are dead set at remaining at home and getting home care. So that can be an option on how to pay for that. Now, what's the difference between Medicare and Medicaid? So Medicare is the traditional health insurance type policies that you get when you turn age 65 or older. Unfortunately, this covers very little long-term care, 30 to 90 days maximum. Now, most people end up needing long-term care 2 to 3 years. So you really can't rely on Medicare to pay for long-term care. It's just, it's not doable since most people really do need it for longer than that. Medicare is great for paying for inpatient rehab. Let's say you've been in the hospital for a while and you need inpatient physical therapy, then Medicare is great at paying for that. And they're also really good at paying for hospice as well. Now, in order to get that inpatient rehab paid for, you have to be designated when you're in the hospital as an inpatient, as opposed to under observation. If you are just in there under observation, then Medicare will not pay for inpatient rehab. And so inpatient rehab, that's kind of approaching memory care type costs, at least $10,000 a month. It is massively expensive. So if you do need to go into the hospital for any length of time and you are on Medicare, fight tooth and nail to be sure that you're getting that inpatient designation, because it can save you thousands and thousands of dollars. So then let's move on to Medicaid. So there's two general types of Medicaid. The first type is the traditional insurance for low-income people, under age 65, or not necessarily under age 65, but who don't need long-term care. The second type, which we'll be talking about for the rest of the presentation, is that does pay for nursing home care and as well as other types of long-term care. But you have to meet medical and financial requirements for that. So the two types of Medicaid for long-term care, you have Medicaid for nursing home care, which is considered traditional Medicaid, or you have something called COPES, and that is for assistance with activities of daily living. So we're talking bathing, using the restroom, walking, feeding yourself, other things like that. Now, what is very tricky about Medicaid is that there is a 5-year look-back period. And that means that any property that you give away within 5 years of applying, there's a few exceptions, but very, very few. Any property that you give away, that you can incur what's called a penalty period. And that means that they will calculate from when you are what's called otherwise eligible for Medicaid, and they will make you wait X amount of days. And sorry, I forget if I had done a, no, I haven't, okay. So once in a while, I'll do an example of this, but you can end up incurring a waiting period of several months where you're down to next to no assets and you still have to find some way to pay for your care. And so that can be really difficult, and you really want to avoid giving away money or property as much as you possibly can when you start to get older and you're looking like you're going to need long-term care. Okay, so medical eligibility, that is one of the more straightforward things to meet. You must need medical care that long-term care facilities provide. So pretty straightforward. The financial eligibility is what trips people up the most. You have to meet both income and resource requirements. The income requirements, that is pretty straightforward. Most of my clients never have an issue with that, because basically you need to be spending more on long-term care than you receive as your monthly income. And you know, at least $6,000 per month, that's pretty easy to meet. Now, with the resource requirements, you can have no greater than $2,000 in non-exempt resources. And there's a list on the next slide. So you basically have to be pretty much destitute in order to qualify for this. A single person can keep about $70 per month of their income. The rest of the income has to be what's used as part of their participation. That means that they have to pay the remainder of that to the facility every month, and then Medicaid will come in to pay for the rest. Now, with a married couple, the well spouse, so the spouse who doesn't need Medicaid, can keep about $58,000 in non-exempt resources, and they can have unlimited income. Now, exempt resources, so the resources not counted towards that $2,000 or that $58,000 if you're the spouse. You can have a home as long as it's worth less than $592,000. Now that goes up yearly. So last year was about $10,000 less. I suspect next year it'll be a little over $600,000. You can have any and all household goods and personal effects. You can have one vehicle, and that vehicle has to be used for transportation to and from doctor's visits. They don't care how much it is, how much it's worth, but you have to use it for doctor's visits. You can't have a life insurance policy, but the cash surrender value has to be less than $1,500. So those are virtually unheard of. I remember when a couple of years ago when I did a presentation in front of financial planners, and there was laughter throughout the audience because they've never seen anything like that. So for all intents and purposes, life insurance policies are not an exempt resource. Most burial plots and prepaid funeral and burial plans are exempt, and as well as items used for self-support, such as durable medical equipment, so canes, walkers, etc. All right, then moving on to aid and attendance. So this is a VA benefit that can be really helpful to very often help overcome that private pay requirement that a lot of facilities have. So in order to be eligible for this, you need assistance with at least 2 activities of daily living, so bathing, toileting, etc. You have to have served at least 1 day during a wartime period, and I have a list of those, I think, on the next slide. You cannot have been dishonorably discharged, and if you're the surviving spouse of a deceased vet, you cannot have gotten remarried to a non-veteran. Now, if you are a married vet, you can get about $2,100 per month. A single vet can get a little over $1,800, and a surviving spouse can get about $1,200. Here are the wartime periods: World War II, Korea, Vietnam, Persian Gulf, and pretty much out of time, but we'll just do this last slide. You can have a maximum of $129,000, and this is for, they don't make the distinction between the surviving or between married couples and single. So you can have $129,000, which includes your yearly income. So if you bring in $29,000 of income per year, you can have $100,000 of resources. Your long-term care costs have to be more than your income. There is a 3-year penalty period as opposed to a 5-year. There used to not be any, but I think it was about 2 years ago that they imposed one. And the exempt resources are the same as Medicaid. One big point that I do want to make about this is it's a good idea. VA benefits are notoriously difficult to qualify for, and the applications are about as confusing as they come. So you really want to be sure that if you do apply for this, that you are getting help, and whoever is helping you apply, typically a veteran service organization, they have to be accredited, and they are not allowed to charge you for the VA application. So 2 big points. You want to be sure you're working with somebody who knows what they're doing. Okay, and that's probably the fastest I've ever gone through one of these. Thank you so much for your time, and I'm sure your heads are spinning. So I would like to pass this off to Athena, and I think I need to make her a host. Okay, just give me 1 second. Make host. All right, Athena, it's all yours.
Excellent. All righty. So I think we're good to go on my side. So yes, we're doing the questions and answers, and if you submitted them on the Whova app, I'm going to be reading them off. And so here we go. The first question is, I have a will or a trust created for Washington and then moved to a different state. Do I need to have them redone in the new state?
Yes, the short answer to that is yes. Every state has different laws, so it's always a good idea anytime you move to a different state to go to an estate planning attorney and get the documents updated to comply with those states' laws. And one additional point I want to make about that, it's a good idea, even if you continue to reside in the same state, to get your documents updated or at least reviewed once every 10 years, or if you have a significant life event happen. So that would be marriage, death, birth, divorce, change in circumstances, etc.
All right. And the second one, what are our options for applying for Social Security when given a prognosis that isn't good?
So I do not handle Social Security benefits. I know they're in Puyallup. I think it's Rose Law Firm. That's the main one that I know of. He is an expert in Social Security benefits.
All right. And the next, or actually the last one I have on here, what are your thoughts on estate planning for cancer survivors whose cancer might return? Please address the family issues. And I think most of the family issues you've already touched on. I guess so. I guess the first part of the question might be needed to be answered.
Sure. So I can talk a little bit about that, especially if you said this is the last question, so I can take a little bit of time. So definitely at least get a will, durable power of attorney, healthcare directive in place. Those are the essential documents. And when you get your durable power of attorney for healthcare and your healthcare directive in place, you want to be sure that next time you go to see your doctor, you are bringing those two documents in so that they can be scanned into your medical records. And that way, when you do need to go to the hospital or if you're going in to see another specialist, they can easily pull those up for you. And also with a durable power of attorney for finances, you want to go into the bank and submit that to them. And ideally, you want to bring in the person who you have named as agent in with you to that to the bank. That'll make things easier. Sometimes banks are a little difficult to work with. Let's put it that way. With dealing with durable powers of attorney. So it's best if you go in with the durable power of attorney and your agent to get your agent on there on your accounts as a durable power of attorney designation. So then they can more seamlessly start paying your bills. And then kind of going on to the medical side a little bit. One of the big powers that the durable power of attorney for healthcare has is the ability to provide consent or refuse consent for medical care and procedures. And at least in my document, that is, I purposely write that in a very broad way. And part of the reason I do that is to give you and your agent the ability to be flexible, but at the same time, you really want to sit down, talk with your agent, and talk with your kids too about what you want and don't want done and what you want your quality of life to be. You know, if you do have stage 4 pancreatic cancer or something like that, you're probably not going to want a lot of life-sustaining measures at that point. Or if you do, that's very much your choice as well. And also a tricky thing that can come up, especially at end of life, is, this is a stressful situation for everybody, you as well as your family members. And so you really want to try to get your close family members on the same page as you. So these are horribly difficult conversations to have. But it's much better to try to get everybody on the same page so that you don't have, let's say, one of your children arguing with one of your doctors.
What happened was, poor Cherie talk about getting an ulcer. I told her, Tom.
Okay. Joanne accidentally popped in there, but you really don't want one of your family members to try to prevent the withdrawal of life-sustaining treatment when you otherwise would want that done. So really, really try to get everybody on the same page, hard as that may be.
Excellent. So just to let everybody know, if you have another question that you would like Bryana to actually address and look at it, you can still actually submit your question on HOVA. It's archived. And so she'll be able to get back to you on the app about your question. All right, everybody. Thanks for coming. I'm glad that we had a good talk and conversation. So we'll see you guys all later.
Bye. Thank you so much for coming, and thanks for your attention.
Yes, thank you.